This training module is legal compliance and what everyone needs to know and be aware of relative to the longstanding U.S. laws and regulations pertaining to antitrust. Most of the laws in place on this topic have been in effect since the late 1800s or early 1900s, so there are no recent changes or updates relative to the legal aspects of antitrust. You just need to be aware of the scope and the basic principles of antitrust as they pertain to daily business activities, any discussions with customers, or interactions in the marketplace. The outline for this training will include, first off, the rationale for antitrust laws. Why do they exist? What's the purpose? The 6 core principles for antitrust laws, the basic framework for antitrust laws, and then there are 4 relevant U.S. laws in place pertaining to antitrust that we'll review at a very high level. And subsequent to that, possible antitrust violations to avoid in the forms of any forms of agreements or any other conduct that may violate antitrust laws, even if there's not an agreement in place. Specifically, matters of particular interest to trade associations where you may have interactions with customers or competitors or other suppliers. Preventing problems in meetings or contacts with others, again, coming back to trade associations or discussions with other participants in the marketplace. And then lastly, we'll just touch on state antitrust laws relative to what's in place at the federal level. The rationale for antitrust laws, first of all, the objectives. Antitrust laws are statutes or regulations that are designed to promote free and open markets. They're also referred to as competition laws, and essentially antitrust laws prohibit unfair competition and again, promote free and open markets. Competitors in an industry are not permitted to use certain tactics such as market division, dividing up markets, price fixing, or agreements not to compete with certain segments of the market or excluding customers or other suppliers from competing in a specific segment of the market. In some instances, companies cannot abuse their monopoly power if they have a very high share of the market to force smaller competitors out of business. The main purpose for antitrust laws are to protect and promote competition, to protect consumer welfare, and essentially stop any activity that will raise prices or diminish the quantity or quality of products and services provided. Fundamentally, the U.S. economy is based on business models and business decisions that promote competition. With more competition, that leads to a wider selection or availability of products and services at lower prices and essentially better service and quality. Contrary to that, in a monopolistic situation, there are fewer products and services available, tend to be higher prices, and that leads to poorer service and quality. Let's go through the 6 core principles of federal antitrust law. First of all, competition encourages customer choice in the selection of goods and services better than any other market mechanism. Competition creates incentives for sellers and suppliers to be innovative in terms of providing quality products and services. Competition is an effective market force for controlling costs and forcing businesses to be more efficient in how they conduct their day-to-day operations. Antitrust enforcement is really critical to preventing and removing any anti-competitive practices such as price fixing, boycotts, any sort of schemes that would end up in terms of a market allocation situation, and any other anti-competitive practices that may impede market reforms. Antitrust enforcement prevents transactions such as mergers or joint ventures or acquisitions that give dominant market participants too much quote unquote market power that could lead to high prices, reduced services, or exclusionary practices. Again, alluding to the comment that I made earlier about a monopolistic situation. Enforcement is not intended for the most part to pick winners and losers, but really to keep the playing field open, to let competitive forces and not necessarily regulations shape customer demand and industry responses. The basic framework of antitrust law is really designed to promote vigorous and fair competition in order to provide American consumers with the best combination of price and quality. There are mainly four federal antitrust and trade regulation laws that were created pertaining to antitrust laws. The original antitrust law was the Sherman Act of 1890. So obviously this goes back over 150 years and is really considered to be the cornerstone of antitrust law. Subsequent acts enacted around antitrust, the Clayton Act of 1914, the Federal Trade Commission Act of 1914, and the Robinson-Patman Act of 1936. So those would be the four primary federal laws that we refer to as we go through this training. These federal laws are enforced by the U.S. Department of Justice, and they have the authorization in situations where there are violations to prosecute violators as criminal felons, and they could lead up to either severely fined or in some cases on an individual basis may be imprisoned. The Federal Trade Commission, based on the Act of 1914, has its own statutory authority to enforce antitrust laws through civil and administrative proceedings. The relevant laws, let's start with the Sherman Antitrust Act. As I indicated earlier, this was really the cornerstone of all antitrust laws and regulations. It prescribes the rule of free competition among those engaged in commerce. It broadly prohibits anti-competitive agreements and unilateral conduct that monopolizes or attempts to monopolize the relevant market. It's really aimed at prohibiting conduct which unfairly tends to destroy competition, and this could include agreements between competitors to fix prices, divide up markets, establish exclusivity contracts where anti-competitive effects outweigh the pro-competitive benefits. Monopolies, attempted monopolies, or a conspiracy to monopolize markets where any single entity has in general more than a 70% market share. In some cases, there may be suspicions of monopolization down to as low as greater than 50% market share, but the real threshold volume that's looked at by the federal agencies is 70% market share. Exclusive contracts, bundled rebates, predatory pricing, which tends to be below cost, abuse of a patent situation, or any other behavior to exclude or disadvantage competitors in an attempt to monopolize. So that's the basic framework of the Sherman Antitrust Act. That was subsequently supplemented with the Clayton Antitrust Act of 1914. And essentially, the Clayton Act addresses certain activities that were not included within the original scope of the Sherman Act. It seeks to capture anti-competitive practices in their incipiency by prohibiting certain types of conduct that's not deemed to be in the best interest of a competitive market. This could include specific laws relative to price discrimination between different purchasers, exclusive dealing agreements, tying agreements where you have one set of circumstances that relies on another, and lastly, mergers and acquisitions that could potentially reduce market competition. The third act is the Federal Trade Commission Act of 1914. This act outlaws unfair methods of competition and unfair acts or practices that affect commerce. It also governs interstate commerce, attempting to maintain a healthy economic competition. It's also worth noting that this is really considered to be a catch-all enactment. Obviously, the Clayton Act was enacted the same year, but this is really designed to include all prohibitions of the other antitrust laws as well. And for the most part, the Federal Trade Commission Act won't have an impact on day-to-day operations of the sales team. It's at very high level and is really aimed more at entities and businesses that attempt to establish unfair competition. The fourth act is the Robinson-Patman Act of 1936. This is also referred to as the Anti-Price Discrimination Act, and essentially it prohibits anti-competitive practices by producers. It prevents suppliers, wholesalers, or manufacturers from supplying goods to quote unquote preferred customers at a reduced price or, as I mentioned earlier, predatory pricing, which may be below cost, and also prevents coercing suppliers into restrictions as to who they can or cannot sell their goods or services. If there are at least two sales of the same product at different prices, this element of the statute is met if, first of all, the product is for the same project or application, and there are allowances where pricing can be different based on order volume size or based on terms, whether it's credit terms, payment terms, shipment terms, etc. Those are all differentiators when it comes to the quote unquote selling price or market price of a given product or service. Specifically, back to the Sherman Act, the foundation for the antitrust legal compliance is based on agreements among competitors, customers, or suppliers that unreasonably restrain competition. Any type of agreement, understanding, or an arrangement between competitors, whether it's written, oral, express, or implied, that limits competition is subject to antitrust scrutiny by the federal government. Some examples of types of agreement that may be found in violation of antitrust laws. First is referred to as price fixing, or another term is bid rigging. These are agreements between competitors on prices charged for products, assets, or services. And it may also be illegal if they indirectly affect prices, such as discounts, promotional allowances, standardization of customer delivery services, or uniform credit terms or billing practices. And it also includes any sort of collusive bidding practices among suppliers or producers. The next is resale price agreements. These are agreements between a seller and a customer on the price at which the customer will resell their product to the marketplace or to the downstream products, whether it's in our case, a tier supplier or an OEM. The next agreement pertains to those that allocate markets, customers, territories, or products. It's illegal for competitors to agree to divide or allocate customers or territories, or to refrain from selling a certain product within a defined geography or category or segment of customer. Also within the Sherman Act, continuing with the types of agreements that may be found in violation of antitrust laws, group boycotts or collective refusals to deal. These are agreements that will boycott or refuse to buy from particular suppliers or sell to particular customers. Agreements to control production. If there's a limited capacity available, these would be agreements among competitors to increase or restrict services or production levels, and could also include limiting the quantity or quality of production, restricting products or services that are sold to a particular customer, refraining from introducing new products to the marketplace, or contrary, eliminating old ones or accelerating the withdrawal of a product or service from the marketplace. Exclusive dealings, requiring a customer to sell exclusively the products of a particular company or supplier, or coerce a supplier into refusing to sell its customers to its customers' competitors. Reciprocity is also covered by the Sherman Act. This is an arrangement where a customer makes a purchase from a supplier only on the condition that the supplier will buy products or services from the customer. Product standardization. Competitors may create lawful agreements to establish industry products and standards. However, there may be situations where this creates problems if there's an anti-competitive effect. For instance, where standardization makes it easier for competitors to establish or set common prices. Beyond the Sherman Act, other conduct that's not directly related to agreements that may violate antitrust laws. Monopolization, as I alluded to earlier, whenever an enterprise enjoys a strong market position for a particular product, whether it's 50% or 70% share of the market, it should be concerned about questions regarding monopolization. No enterprise should take actions that might be viewed as evidence of an intent to acquire or maintain monopoly power in a particular market, or to drive a competitor out of business or prevent another enterprise from entering the market. Price discrimination, which stems mainly from the Robinson-Patman Act. This restricts sellers from charging different prices for goods and services to competing customers at the same point in time. It forbids sellers from discriminating when offering promotional materials, services, or any other type of inducement to individual customers in an effort to have the customer engage in in-house promotions or advertising. Buyers, in turn, are prohibited from knowingly inducing or receiving a discriminatory price, promotional allowance, or service. Unfair competition, which is alluded to under the Federal Trade Commission Act, prohibits all unfair methods of competition and unfair or deceptive acts or practices. This prohibits all forms of deceptive or misleading advertising and trade practices such as disparaging a competitor's product, harassing a product or a customer or competitor, or stealing trade secrets or customer lists. As it relates to trade associations, some additional matters of interest that you need to be aware of. Whenever participating in trade associations by membership, the very nature provides certain commercial and other benefits to its members. Denial of a membership to qualified competitors of the members could violate antitrust law. Membership in a trade association should be open to all companies that satisfy basic membership requirements. Certain programs or activities may need to be opened up to non-member companies if their exclusion would put them at an unreasonable competitive disadvantages to those that are enjoyed by the member companies. Collection and dissemination of data. Statistical data may be compiled for legitimate business purposes. However, it may cause problems from an antitrust standpoint if the use of the data somehow or in some fashion harms competition. As a general rule, particularly market-sensitive data supplied by individual member companies should never be discussed or disseminated without legal guidance, either to an individual company or to members of a trade association. Code standards and certification programs. In most cases, reasonable industry code standards and certification programs may promote valid interests, including and specifically as it relates to the protection of safety, health, and the environment, or maintaining high standards of ethics and conduct. However, you need to be aware of situations where a product standard that is unreasonably biased in favor of one manufacturer's product at the expense of another, as this may raise antitrust questions and concerns. Marketing and communications. Be careful that all advertising, announcements, and other communications to the marketplace that might affect competition are accurate and are in no way deceptive or misleading. Cooperative advertising programs may be suspect if they discriminate or benefit certain companies at the expense of their competitors. Preventing problems at meetings or industry contacts with others. Just need to be aware that meetings, communications, and contacts that test on antitrust matters present specific challenges. Suppose, for example, that competitors were to discuss their prices at a meeting or in a document, and that their prices increase shortly afterward. A jury might view this as evidence that their discussions led to an agreement on pricing and thus in some way violated antitrust laws. In a case like that, the mere appearance of illegality, even when the parties may in fact have done nothing wrong, can cause serious problems. Some fundamental guidelines when you're attending meetings where suppliers and or competitors may be present. In general, you want to avoid any subjects that might raise antitrust concerns, whether it has to do with pricing discussions, market allocations, any special deals that are in place. Need to be sure to avoid any aggressive language, even in a joking context. For example, let's take out our competitors, for instance, would be alluded to. That could cause serious concerns from an antitrust standpoint. And when you're attending a meeting or having contact with others, if someone begins discussing a sensitive subject, you can either stop the discussion or leave the meeting. The last topic has to do with state antitrust laws. In addition to the federal antitrust laws, all U.S. states have their own market competition laws, but most regulations in place at the state level mirror what's included in the Sherman Act or those that are enforced at the federal level. Many states also have unfair competition laws that are similar to the Federal Trade Commission Act. And at the state level, the attorney generals are responsible for enforcing the state laws. In some situations, it is possible to have simultaneous both federal and state antitrust enforcement actions or investigations pending certain cases. So you can have both federal and state cases that are being investigated at the same time. So this concludes this training on legal compliance specific as it relates to antitrust. Please be sure to complete the assessment questionnaire that follows below. Thank you very much for your time and attention.